Good afternoon. Thank you for joining us. Up now, we have IP in the toy industry, presented by Frank Sardone. Frank?
Thank you, Ann. Hello, everyone. Good afternoon. We have a lot of material to cover in a little bit of time, so I'm going to try to get through it as quickly as possible. This is going to be more of an overview of intellectual property in the toy space and seeing, how some of these things apply for what you may or may not be doing. So what is intellectual property? I'm an intellectual property attorney, so I do patents, trademarks, copyrights. I help clients acquire IP rights, help them clear products to avoid other people's patents. I do not litigate. We'll get into that in a second. So patents, intellectual property, it's an intersection of patents, trademarks, copyrights, and trade secrets. I'm going to give everybody an example of some of those and how some products have an overlap of all those things or some of those things. So it's not just one thing that you have to focus on. All right, and so here are just some 4 basic examples of what a patent is. A patent protects an inventor's systems, widgets, or processes. That's from the Patent Office. Think of the Super Soaker, for example. Trademarks, that's the brand, the logo that people associate with the products, Coca-Cola. Copyrights are protected to the author for tangible expressions of software, arts, works of performances, so Hunger Games or any number of novels or workbooks and stuff like that. And trade secrets, which we'll talk about in a second as well, it protects formulas, ingredients, and if you think of Play-Doh, how that's made, or Aaron's Crazy Putty, who knows what that's really constituted of, but those are secrets, and we'll talk about those real briefly. So here's just a quick example of something that includes multiple of those items that we talked about. It's a game where the cards were presented on dice, and so you'll see it's got a patent for a utility patent for the way it operates for the dice or for cards on dice. It has copyright for the artwork. It has a trademark for square shooters, and it might have some trade secrets, which we'll talk about again, just for an example. Why does IP matter? And we'll talk about it as well. This is just an example. It's not quite specific to the industry, but Apple, you can see their trend in dollars. This is as of 2021. They've spent $22 billion on IP. So, they're protecting their products. They want to lock up their rights. Who are IP attorneys? Myself, I'm a prosecutor, meaning that I present my clients in front of the Patent Office on their behalf to help them get patent rights, trademark rights, or copyrights. We're attorneys. We have law degrees. Sometimes there's patent agents, which can present on your behalf in front of the Patent Office, but they cannot be in court. We usually have degrees in hard sciences, so my background's mechanical engineering, chemistry, physics, electronics, software. And we work with the U.S. Patent and Trademark Office. You may have heard them here yesterday. They have a booth here for obtaining rights. The Library of Congress, if you're looking to register your copyrights. Other departments and agencies that we work with. And then there's litigators, which they focus on asserting or enforcing intellectual property rights on behalf of clients. I don't do that, but certainly, that's a whole other part of the equation. And they work in the U.S. patent court systems and the federal and state court system. Where do you find us? Well, here's a good spot, but local legal bar associations, you can find patent attorneys, intellectual property attorneys at the Patent and Trademark Office. There's a roster. There's a limited number of us. Local inventor meetings, United Inventors Association, any of your local associations, you can find patent attorneys or intellectual property attorneys hopefully attending. Trade shows, TIA, POP, for any of those that attend some of those events, you might find some of us there. Conferences, referrals or recommendations are always great, so you have word of somebody who's already experienced with them. The internet, but do your due diligence. It's going to be a long process that you're going to be working with us, so we're not going to be done in a few months or a few weeks. It might be a number of years. So you want to find the right match patent protection in the US, the idea that you have must be new, useful, and not obvious, legal stuff, but speak to an attorney about what those mean, because they have very specific meaning. Whatever your idea is, it must be new, it has to be useful, and can't be obvious. You must be the inventor for a patent. The patent can only be provided or awarded to the inventor or the company through which the inventor works for, but no one else. You have 1 year within which to file your idea if you've already made a public disclosure. This is an important date. So you might attend a trade show, you might talk to somebody, you might share your idea with them, but then the clock starts running in the United States, that you have 1 year to then file at the patent office, or else your rights could be gone forever. Foreign rights are absolutely gone as soon as you make a public disclosure. Additional obstacles to patents, cost. There is a cost associated with. It might be expensive, it may not be expensive, depending on what it is. Time to obtain the patent. At a minimum, you're looking at 18 months. We can fast track it for a cost, but you're looking 18 to 36 months. So if your idea might be in and out of the marketplace in less time than that, it may not make sense, right? Enforceability. There's no patent police out there, so you are the patent police, or the litigators that you're going to hire to be the patent police. So that's a cost that's going to be associated with enforcing your rights to make sure nobody's infringing on your patents, to ask them to cease and desist, lawsuits, certainly cost involved with that. So is it worth it? There's a lot of obstacles ahead of you. Here are 4 examples of patents. A toy figure, a dye agitating device, self-propelled device for interpreting input from a controller device, and system and method for filling containers with fluids. What are these patents, right? You're wondering, what are they, right? Toy figure. Right, do we recognize this guy? Was he worth it? Right? Licensing opportunity, right? Dye agitating chance device. What could that be? Does that look familiar to anybody? Maybe, maybe not. Trouble, the game? Was that worth it? Maybe yes, maybe not. Self-propelled device for interpreting, very long title. So there's this patent. Doesn't look familiar yet, maybe. It was here at Toy Show several years ago. Does this look familiar to anybody? It's a remote control ball called Spark at the time. Company called Sphero. They licensed it, marketed it, and turned it into BB-8, remote control BB-8. Maybe it was worth it. I don't know. Assisted method for filling containers with fluids. Anybody look familiar? Bunch of balloons, right? They got a patent on that, right? Bunch of balloons, and there was also a balloon bonanza. Looks a lot alike, doesn't it? Well, there was a lawsuit. Bunch of balloons. They won an injunction to stop telebrands from selling balloon bonanza. After 4 years of litigation, they settled on $31 million in compensation. Just an example. Simple idea, but powerful. Trademarks, service marks, these protect words, symbols, etc. Right? Brand for your product or company. Market gives you market recognition. Federal trademark applications, they're examined by the US Patent and Trademark Office. They're enforced in federal court. These are just some examples that you recognize on the screen here. Big Mac, the ultimate driving machine, BMW, right? American Express. But non-traditional marks, other things that can get trademark protection that we don't think about. Sounds. The NBC bells, those have trademark protection. Play-Doh, the smell, the actual smell of Play-Doh has trademark protection. So if you have some iconic smell with your product. And colors. Brown to UPS for delivery services, that's protected by trademarks. Just examples, right, for you to think about. Trademarks, trade dress, The iconic Hummer, it was copied by Lannard Toys. There was a lawsuit because it was too similar to the actual Hummer vehicle itself that General Motors has trademark protection, trade dress protection for. So be mindful if you want to create products that look like BMWs or actual vehicles out there, or Grand Theft Auto that are using, you're going to have to get licenses from them and authorization and approval from the actual car owners. Magic the playing cards, copyright protection. This was another lawsuit. They settled out of court, so I don't know the details of it, but just an example that copyright, the artistic look of it, could be something that you want to protect if something comes too close to what you've actually created from an artwork standpoint. Limits to copyright protection. For example, here, we have this game, Tizico. Da Vinci had a similar. While the expression is protectable, the actual way the game is played was not protectable. So I give this example, it's Apple to Apples. Anybody played Apples to Apples? Right? Yes? How is that different than Cards Against Humanity? Similar? Maybe? Topic is a little different, right? So some people wait until they're being ripped off to register trademark or their copyright protections. Some people refer to a poor man's copyright. They just mail it to themselves. We spoke yesterday, or somebody spoke yesterday about it's inexpensive. Just get it on file. You can contact us. We'll tell you how to do it if you want to use us to help register your copyrights. It's a powerful deterrent to register your copyright. You can get multiple layers of damages, and it's very simple, very inexpensive compared to the other 3 trademarks or patent protection. So it might be a very convenient way to go. Some figures that were protected by copyright. This is Angry Birds, called ill-tempered birds, but the same kind of bird, right? But protected by copyright. The earlier you register, the better. Copyright Office. Why does IP matter? It increases your monetary value in your products, your company. You can charge a premium for your product. Anybody recognize this? Do they charge a premium for their product, perhaps? Tiffany, right? Blue, that's also trade dress, that blue color. They charge a premium for their product. So starting a toy company, right? Research the marketplace. Do you want to even start a toy company? Register the business name before you even get out there in the public, because there's going to be people going to register before you even register, and now you're going to have to change your name. So before you publicize your business name, make sure to register your business name with the Attorney General in your various states where you're doing business. Social media, lock up your social media accounts, because those are going to get taken up if anything's really popular. So lock those up. Arrange for accounting. Accounting's going to be incredible with accounts payable, accounts receivable. Innovate. Make sure your product is innovative. Innovative. So patents, trademarks, copyrights. Artificial intelligence is getting larger and larger. We see it all over the place now. Can your product be enhanced by that? And non-fungible tokens, this was a thing not too long ago, but NFTs. Can we integrate NFTs into your product? Maybe yes, maybe not. Manufacturing, find reputable manufacturers. Shipping, inventory, insurance, products liability insurance, shipping insurance, all kinds of things that go into starting a toy company. Consider licensing, product testing, or accreditation, we just heard about. UL for items that have electronics or plugs or power to them. Choking hazards, Prop 65 in California, things to think about that you're going to, if you want to embark on producing your own product, that you have to deal with. Just a few of the items. So this, right? More examples. Just want to give you guys more examples to open up your thoughts about what can be protected. People recognize this? Yes? Good. What's this protected by? Patent? Yes, patent. Patent's only good for 15 years, 20 years at most. So still protected for other reasons. Trademark, trade dress. It's got that shape. You don't see other lamps like that because they have a trademark for lava. Nobody else can call their lamps lava because of the trademark. And trademark doesn't have any expiration so long as you continue using it. And the government's going to want money every so often, but so long as you continue using it, nobody else can use lava. And they also have a trade dress design to that shape. So again, so long as they continue using it, nobody else can come in with that same design. And copyright, trade secret, I talk about, because nobody really knows what the formula is that's in there except for the lava company. I mean, they talk about it in their patent application, but it's kind of vague. So the actual formulation of what's in there, the temperatures, that everything, all the magic happens, nobody really knows. They've kept that a real trade secret. So think about that. Other examples. We're going to run through these in a few more minutes, right? This guy, people recognize this guy. Why is he up here? He's got lots of different protections on him. Patent? Yeah, really? It's got a patent. Was that important? Was it worth it? Maybe. Did they license it afterwards? Trade dress, copyrights, all these things, cover Optimus Prime and Transformers. That was the original Optimus Prime. I own this as a child. It's actually on my shelf at home. More examples. This guy, people recognize Voltron? Maybe yes, maybe not. Not as popular. Trade dress, copyrights. It's a whole box set, all these different things. Selling for, not too long ago, $240 online to this day. Licensing opportunity. Oh, I missed some things. Where to go? Artificial intelligence, NFTs to help create artwork. Just think about these things, how they apply to what you're working on. These are definitely a thing. If you do enter in the artificial intelligence, the meta world, the metaverse, how does your integration in there affect real world patents, trademarks, copyrights? Marketing, Slanket versus Snuggie. People recognize these two companies? Slanket was the first to actually produce the wearable blanket, but who really knows Slanket compared to Snuggie? But neither of them had patent protection for it. But Snuggie was such a better marketer than Slanket that they certainly outperformed Slanket in the marketplace. So think about that. There's no patent protection. There used to be patent protection that expired, but Snuggie certainly outmarketed Slanket. Iconic patents. This guy, right? Super Soaker, was it worth it? This guy, was he worth it? The Rubik's Cube. Just things to think about. Oh, and this guy, the pop socket, right? That's all I have. I have a few more, just a couple of minutes. Open the floor for questions. I have some handouts here about myself, the work we do. I'm here to answer some questions, as time permits. Yes? No, patents cannot be renewed. Once they expire, they expired. Patent Office requires the owner to pay a fee every 7, 11, and 14 years. So if you don't pay the fee to the government, it expires and it's available to the public. So, but no, they cannot be renewed.
And paying for, and then you stop using it. I gather from what you said, someone else would come in and start to use it.
That is correct.
And if they do, and then you want to get it back, do you have any extra rights to it from your historic use of it, or not?
Very fact specific. We might have to look into, what potential use you may have had in that interim where you let it go. Toys R Us might be one that they closed up their operation here, but they still have Toys R Us. So something to think. We have to very, very fact specific, but most likely, no. Questions? 30 seconds. I'll be here on the side. Please feel free to a handout. Hopefully this will open up some thoughts for all of you. Thank you all.